Is that working? Yeah. Buenos días a todos y gracias por estar aquí hoy temprano por la mañana y, por la oportunidad de discutir temas muy importantes, internacionales, y voy a continuar ahora en inglés porque para mí está mejor. So, thank you all very much, and thank you, Ricardo, for introducing us. Let me first just recognize the partners from our firm who are here with us today. Kiara Spector Naranjo, who is our colleague here in Chile, and who I met for the first time today. I'm looking forward to, I can't say much about her because I just met her. We also have with us our colleagues. Manuel Varela is our colleague from Washington, D.C. He runs our Latin American practice group, and we work very closely with him every day. And our colleague, what's your name again? Christian Francos? Christian is our partner in Buenos Aires, and he has been a great asset in Buenos Aires in introducing us to a lot of the Latin American banking sector. And if you talk to him, all he'll tell you is Pope, Pope, Pope all day long. That's all. So thank you all very much. Arthur and I, our background, we began together working in the district attorney's office in Manhattan on the same day in 1994. We have been friends for almost 20 years, and we together had the responsibility of supervising and being in charge of the International Economic Crimes Bureau for the district attorney for a number of years, pursuing such crimes as international money laundering, terror finance, bank fraud, securities fraud. And those cases brought us all over the world chasing dirty money. It gave us the opportunity to work with people in the private sector all over the world, to work with lawyers all over the world, to work with law enforcement all over the world. And it gave us, I think, for the United States, a fairly uniquely international perspective on law enforcement and international banking. Arthur left to go work for J.P. Morgan Chase, and he'll tell you about that, but he basically worked in anti-money laundering globally, making sure and preventing dirty money, criminal money, from coming through the bank. And then when J.P. Morgan decided that it needed to create a firm-wide global anti-corruption program, they asked Arthur to build the program and then to run it. And so he did that for a number of years. And then we decided together, we had talked about this for years, that it was time to pursue our goal of joining a small international firm and working in this area of anti-money laundering, anti-corruption, and helping financial institutions prevent dirty money from flowing through them, and also helping corporations and firms in their relationships with the United States. And one thing that we're seeing more and more is an increased globalization of the expectations and standards in the area of money laundering. We look at institutions such as the FATF, and we see the norms that they publish and the importance of those on the global stage. We see what is expected of financial institutions in the United States and the level of knowledge and the amount of work that regulators and prosecutors are telling our banks they have to pursue in order to do business. And when the regulators tell our banks that they need to work in this area and know so much about their customers, that has an effect outward from the United States, where the United States banks are saying to their non-U.S. counterparts, we need to know more about your customers and your operations. And so one of the things that we see is that the United States regulators, the United States banks are taking a lot of time to ask a lot of questions. And the reason driving that is a rising standard for anti-money laundering, anti-corruption, and sanctions compliance. What we'd like to do today is share with you some of the perspectives we have from working in anti-money laundering in the United States for so many years, and from working both inside one of the biggest financial institutions in the United States, and from my perspective, working from outside, interacting with those financial institutions and with the regulators to pursue some of the biggest money laundering cases that have come out of the United States in the last 5 or 10 years. A couple of points I'll make in listening to Ricardo's comments, and I know that one of the sponsors here is the university. So from a sort of legal jurisprudential perspective, I think it's significant that Chile now is providing for the culpability of corporate entities, which from my past experience I know is something very new for civil code countries, to have criminal liability for corporations. We've had this for a long time in the United States. There's a common law concept known as respondeat superior in Latin, meaning that the superior is responsible for the acts of its agents. And what we've seen is a body of law that allows for the culpability of the corporate entity when its employees or officers engage in intentional criminal conduct. And the level of the employee is, of course, relative to whether criminal conduct is imposed. In the state of New York, it has to be a high-level employee for criminal conduct to fall on the corporation. But in the federal system, technically, it can be any employee acting within the scope of his or her employment, leading to culpability for the corporation. As a practical matter, if a bank clerk steals some money from a client, the corporation won't be responsible. What the federal law is looking for is high-level involvement and systematic and ongoing criminal conduct within the corporation itself. In the realm of money laundering, we've seen a lot of change, especially very recently. Money laundering in the United States exists on sort of two levels. We have both federal law, and then each state has its own money laundering laws. And in our federation of states, the criminal law exists simultaneously, both federally and at the state level, and they are of equal import. Generally under U.S. law, if the criminal proceeds come from specified crimes, and there's a long list of crimes, any kind of fraud, any kind of drug trafficking, very long list of crimes, corruption, bribery, and the transaction tries to hide that money or to further the criminal conduct, then that money is laundered proceeds. And under our jurisprudence, the government can seize that money. Under our jurisprudence, the criminal has no ownership interest in criminal proceeds. So if you steal money from someone and you take it, the government can take it away from you because you have no right to stolen funds. And so in our law, we can proceed against the laundered funds directly, saying that we can condemn the stolen money as criminal property and take it, or we can proceed against the individual and obtain a civil judgment that allows us to go after the individual's assets as criminal proceeds. The other area I just want to comment on, because I think it's very important as we think about these issues globally and internationally, is the extraterritorial application of U.S. law. It's been a big issue, especially when it comes to U.S. sanctions. And some of the cases that I've worked on in the last 5 or 6 years are the big banking cases cases that involve sanctions evasion.
I have your remote control.
You're my remote control? Next slide, please, sir. Sanctions are run from the United States Department of the Treasury, the Office of Foreign Asset Control. And what the United States has done is said that our banking sector, which conducts so much business globally, is a weapon or a powerful instrument that can be used to enforce U.S. policy goals. So the United States has designated certain countries and certain sectors of being of importance and concern either for money laundering, when we talk about drug kingpins, or terrorism, when we talk about the financiers of terrorism, those entities that would support terrorist organizations around the world, but also specific countries. And among those countries in the United States, we have the Sudan, we have Cuba, we have Syria. Most importantly in the United States, we have Iran. And that is the biggest issue in sanctions right now. And it's a place where we can discuss extraterritorial application of United States law and the tension that it creates as it conflicts or runs into other countries' laws. And we'll talk about that. Our sanctions laws are strict liability. So it doesn't matter if the firm, for example, sending money on behalf of Iran knew what it was doing or intended to break the law. If the money was sent and it violates the sanctions, there is civil liability to the firm. And the civil liability here is very strict, and the punishments are very severe, up to $1 million US for every transaction. So you can imagine if a bank was engaged in regular commerce with Iran violating sanctions, the penalties become astronomical very quickly, as we'll see in a moment. If it's done intentionally and willfully, meaning they know about the law, they intend to violate the law, then there's criminal culpability, and that's something that we'll see. So let's keep going. We'll talk about extraterritorial. These were some of the big cases that we handled in the last the last 5 years, I'd say. And if you look at them, look at the penalties. I supervised HSBC, Standard Chartered, ING, Credit Suisse, Barclays, and Lloyd's. So 6 of those 7 sanctions cases we handled in my office. And the penalties in those 6 cases added up to $3 billion US. So the penalties are significant. These cases were criminal in that what the banks were doing, they're referred in the United States as the stripping cases. And the reason they're called the stripping cases is because the banks here, all of those banks, Credit Suisse, HSBC, Standard Chartered, they knew that if Iran or Sudan wanted to transact with the United States, if a wire payment went through the United States and it said Iran in it, or it said Tehran, or it said Sudan, or it had an address in the wire payment message, the United States bank automated filters would block the payment and reject it, or freeze it, depending on the type of sanction. So what these banks said to, for example, their Iranian clients is, okay, we'll give you a special service. When your wire payment comes into our bank, so when Bank Melli in Iran needs to send a US dollar payment that's going to go through the United States banking system, when it comes to Credit Suisse in Zurich, we'll stop it, we'll take it out, we'll strip out the information that says Iran, and instead we'll just say Credit Suisse and then send it through the United States so that it will get through the US banking system. And so they did this for hundreds of millions of dollars of transactions and trade finance. And that was the basic issue of what we investigated in these cases, and these were the settlement amounts that resulted. All of these cases were undertaken by my former office, the Manhattan District Attorney, the United States Department of Justice, the Department of the Treasury through OFAC, and the Federal Reserve Bank of New York. This is just more of the same. These cases, many of them become civil cases only, and some of them are not so much money as you get down to the bottom, but they were significant cases for the firms involved, obviously. So I think it's important in terms of sanctions cases to just mention, in terms of extraterritoriality, a few trends in the United States right now. So it used to be, it always has been in sanctions, that for a non-U.S. bank or a non-U.S. corporation, if you had to determine, does this transaction involve a U.S. person, or is it going to go through the United States? Is it, for example, if it's a wire payment, when wire payments are sent between two different countries and they're denominated in U.S. dollars, they pass through the United States. And so if you were transacting, if there was a Chilean company buying steel from Belarus, and it was, the contract called for a payment in U.S. dollars, that transaction would pass through the United States. And if it violated the sanctions, then there was a problem. But if it was transacted in euros, for example, then there would be no problem. And so that's how it always worked. If the transaction didn't touch the United States, then it didn't implicate U.S. sanctions. The United States changed that in the last 6 months. And it's important, as you're advising international banking and corporate clients, that you understand some of these changes, because it can have a direct impact and a direct risk to the firms. We're going to focus on the oil and petrochemical industry because that's where the biggest changes have occurred. So there's a couple of orders here that are significant, all of them from last year. The first one that I have up there, Executive Order 13599. It used to be that if a payment came through the United States and it involved Iran generally, it would be rejected. That is, it would be sent back to the originating bank, and the bank would be told, we're not going to do that business, it violates sanctions. Now it's not sent back, it's blocked. And in OFAC, that's the OFAC term for seized, frozen. We're going to take that money and put it in an account and hold it, and we're never giving it back. So if a firm is conducting business on behalf of Iran or violating sanctions, it will lose that money. The next one is very significant, 13622. And this is where I say the change has come in extraterritorial application. For the petrochemical industry, for Iran's uranium mining industry, and for transactions conducted with the central bank in terms of the exchange of banknotes, it doesn't matter to the United States any longer whether whether the transaction, touches the United States. If a firm in Chile is going to send money to help construct an Iranian oil platform, and it does it in euros, the United States will say to that firm, you may be shut out of the U.S. financial system. So it's not a criminal, it's not an assertion of criminal jurisdiction or criminal authority, but it is a policy assertion saying if you're doing business with the Iranian petrochemical industry, we will shut you out of the U.S. financial system. We will put your firm's name on a list, and you will not be able to transact with the United States any longer. And it's very broad. So it could be buying oil, that's the most direct application. It could also be sending money to build, as I said, construct a pipeline. It could be insuring the ships or insuring the pipeline that's going to be built. It could be trade finance. It could be transporting the oil. Anything to do with the Iranian petroleum sector is now subject to the risk that the United States will say to that corporation or that bank, we're shutting you out of the U.S. financial system. So that's a significant risk, and something that you need to be able to advise your clients. the other ones up there very quickly. So the sanctions, going back to the traditional focus on U.S. presence, it extends to all U.S. subsidiaries and affiliates. So if it's a Chilean subsidiary of a U.S. corporation, sanctions apply. And then the last one, if an entity is helping Iran or Syria evade sanctions, but may not be violating sanctions themselves, then they have this exposure to being locked out of the U.S. financial system. So, for example, what we've seen highlighted from the Department of the Treasury is exchange houses, especially Middle Eastern exchange houses that may be doing currency swaps with Iran and then transacting through other foreign banks. There's an exposure, a risk exposure to U.S. sanctions application if that type of business is going on. What all of this means is that for corporations and financial institutions, there is a new need to do a higher degree of due diligence on foreign operations, particularly in the areas of private equity and joint ventures abroad. So if you are investing in a power plant somewhere in the Middle East, you have to, one of the questions you have to ask, and Art's going to talk about this extensively in terms of corruption, but one of the questions that you have to ask is there a risk of violating or bumping into U.S. sanctions because we're doing something with Iran or Syria? The one other thing that I'll mention is this Section 219 disclosure, because it's also a new requirement. And it basically says that if any company in the world is listed and has to file in any of the U.S. stock exchanges, it has an obligation in its filings to disclose any involvement with Iran. And failure to do so, if it were immaterial, a material omission, and I think anything to do with Iran in the United States today would be a material omission, would violate this section and would subject the firm to civil penalty. Okay, so let me just say a couple other comments, turning back again, because part of the message that we wanted to deliver is I focused on sanctions. Art will focus a lot on corruption. But what we've seen is that if you look at the global best practices and international norms, if you look at what FATF has had to say about money laundering, what's happening in the United States is that it used to sort of be different areas. You had money laundering was sort of the original. Then you had anti-corruption, especially with passage of and implementation of the FCPA and now the UK Bribery Act. And then you had sanctions. And they were considered somewhat different. But I think what we can say today is that all of them, all of the sort of practices that we have for money laundering, and by that I mean know your customer, due diligence, a risk-based approach where you're applying enhanced due diligence to the most risky areas, those money laundering concepts that we take from FATF and that have a more established international presence, we have to apply specifically to corruption and to sanctions, because it's all sort of under one umbrella now. And those increasingly are going to be the best practices that international banks will have to follow, and that U.S. banks will be looking to their non-U.S. counterparts to employ for international business. So what I anticipate you will see increasingly are questions from U.S. financial institutions and corporations about what is your compliance program for anti-corruption. What level of know your customer and due diligence are you performing in these ventures and in these financial operations?